You can protect your kids' inheritance from your husband even if you're legally married. The key is setting up the correct estate plan using a revocable trust, designated beneficiaries, and ownership structuring. If you don't take these steps, your spouse could legally inherit your property even if it's jointly owned, control your kids' inheritance if they are minors, and delay or alter your legacy planning through the probate courts. This applies if your property is either only in your name or if you jointly own it with your spouse. Let's talk about how we would set up an estate plan so our assets go down to our kids and our husband does not have any control over our assets. So let's talk about why estate planning is important when you're separating but you're still legally married. If you're still legally married, even if you are separating, your spouse could take over the inheritance of your properties. They could access and manage your children's inheritance, and they would have control over your estate during the probate process. And they would have control over the management and distribution of your assets through the probate process. To prevent this, you need an estate plan that's going to direct your assets down to your kids and not your husband, that avoids probate delays and costs associated with it, that protects your personal assets from rental property lawsuits, and provides proper financial management for the inheritance that's going down to your minor kids. So step one is going to be building the foundation with a revocable living trust. The revocable trust will allow all of your assets to avoid the probate process. It will allow you to control the management and distribution of those assets going out to your kids, appoint trusted family members to manage the assets on behalf of your kids, and protect your minor's inheritance from your husband mismanaging that money if they are bad with their own financial management. What we're going to put inside of a revocable trust is going to be real estate and property, LLCs that hold rental properties. So we're either going to put those accounts inside of the revocable trust or name the trust as a designated beneficiary. For our retirement accounts, you would have a tax advantage to distribute that money out to the beneficiaries instead of having it go inside of the revocable trust. And then when that money and assets are inside of the revocable trust, you can control the management and distribution of those assets. This would be things like age-based distributions when your kids turn 20, 25, 30, etc. Or event-based distributions when they graduate college, get married, buy their first home, etc. You would have full control over how those assets get distributed out to your kids. That way you're not giving them lump sum distributions and risking them blowing all of that money. Step 2 is going to be handling your real estate correctly. For the first house that we hold only in our name, we're going to transfer that into the revocable trust so that it avoids the probate process. For any assets that we jointly own with our parents, we have two options here. Either we can keep the property as joint tenants with rights to survivorship. That way it avoids the probate process when one of us passes away and goes directly down to the surviving co-owner. Or we would change the ownership structure, the tenants in common, and then put our share of the property into the revocable trust. That way it can be controlled from that trust. And then when we have any rental properties, we put the rental property inside of an LLC so that our personal assets like our family home or other properties are going to have asset protection from any tenant lawsuits. But the LLC does not make that property avoid the probate process. So what we would want to do is put the LLC membership interest inside of the revocable trust. That way the LLC avoids probate, and then all of your other assets inside the revocable trust have asset protection from that rental property. Step 3 is going to be coordinating our financial accounts and our designated beneficiaries. Now, our goal here is to make everything avoid the probate process. So we have a couple different options on how we can handle this. We have our checking, savings, investment accounts, and our insurance policies, and then we also have our retirement accounts. Those two groupings will get handled differently. With the checking, savings, investment, and insurance policies, what you can do is put those into the revocable trust, or you can name the revocable trust as a designated beneficiary. That way, either the money will be inside of the trust when you pass away, or it will dump into the trust when you pass away. And with either route, it's going to be managed and then distributed out to your kids per the instructions inside of that trust document. Now, for our retirement accounts, there are tax advantages to distributing that money out to individuals instead of putting it inside of our revocable trust. Now, the benefit of all of this is that you can direct that money to go direct. Now, the benefit of naming the designated beneficiaries is that all of that money will avoid the probate process. It will go down to the kids or the revocable trust and avoid going over to your husband. Step 4 is protecting your minor child's inheritance. Now, when you pass away the minor child, the guardian is going to be the person that raises them until they turn 18. The guardian is also going to be the person that will be in control of the inheritance on their behalf. Now, it's typical that your husband is going to become the guardian of your child when you pass away, and the problem is going to be if they are not financially responsible with their own money, it's very unlikely that they're going to be financially responsible with your minor child's inheritance. Now, what we can do is put the money inside of a revocable trust to take care of our minor child for things like living expenses, educational costs, healthcare costs, etc. But then the trustee is going to be in control over how that money gets used and distributed out to your minor child, and you are setting up the rules for those distributions. Your husband is not in control of how that money gets used on behalf of your child. Step 5 is going to be naming the trustees. Now, if you have multiple kids, you can have co-trustees where it's two children who are in control of the management and distribution of the assets inside of that trust. Now, the problem is going to be if there is a disagreement between them on how something should get handled, you'll need to have someone who's going to be a neutral third party that can be a tiebreaker for them to make a decision. Now, this can be one of your siblings, a family member, another child, or a neutral third party that you can find to help your kids make a decision when they need a tiebreaker. Step 6 is going to be setting up a pour over will for any assets that you forget to put inside the revocable trust. Now, in the event that you forget or don't have time to put assets inside the revocable trust, the pour over will take those assets that are in your name when you pass away, send them through the probate process, and then instead of those getting distributed per the intestate laws of your state, they would get distributed into the revocable trust to be managed and then distributed per the instructions inside of that trust document. If you want help setting up your estate plan so that all of your assets will go down to your kids to take care of them instead of giving your husband control or ownership of those assets, click link in the bio, fill out the form, and schedule a time to talk to someone on our team.